I'm very pleased today to be introducing Professor Daniel Robinson, Distinguished Professor Emeritus at Georgetown University, where he taught for 30 years. Professor Robinson continues today on the faculty at Oxford University, where he's been lecturing since 1991. We were very grateful in the Madison program to have Professor Robinson here in the fall of 2001 to inaugurate the Charles E. Test lecture series. Each year, as many of you know, we invite a very distinguished scholar to deliver a series of lectures, and Professor Robinson was our first Test lecturer. Our next Test lecturer will be lecturing in November of 2006, and that will be Professor Leon Cass of the University of Chicago, who recently stepped down as chair of the President's Council on Bioethics. Professor Robinson has served as a visiting professor of psychology at a number of institutions, including this one, but also Columbia and Brigham Young University. He's the author of 17 books covering an unusually broad range of disciplines, including brain sciences, philosophy and history of science, moral philosophy, philosophy of law, philosophy of mind, and intellectual history. I was first introduced to your work a while ago, a book you wrote titled Psychology and Law, I believe, that was a very interesting exploration of the insanity defense. He has written perhaps the most definitive history of the legal conception of mental competence. His widely praised book, Wild Beasts and Idle Humors, The Insanity Defense from Antiquity to the Present, which Harvard published in 1996. He is perhaps best known of all for his intellectual history of psychology, now in its third edition. Most recently, he authored a book published by Princeton University's series, the New Forum series, titled Praise and Blame, Moral Realism and Its Applications. Today, Professor Robinson will be speaking to us about Terry Schiavo and the Shibboleth of privacy. Please join me in welcoming Professor Daniel Robinson.
Well, I want to thank the James Madison program for having me come back. I've been told not to lecture into the light, but lecture into the mic. I'll try to do that. And this is a very difficult set of issues that Schiavo raised. I do want to get through some of this quickly and densely, and so I'm going to read to you. But during the question and answer period, I'll create at least the illusion of speaking off the cuff and in an engaging way. If you don't mind, I'll dress Princeton style because it's very warm in this room. I always fear that I'm violating the dress code when I come here, but the actual importance of Schiavo arises not from the competing claims of spouse and family, but from issues larger and more fundamental at the level of law. Of these, I'll confine my remarks today to two of them, that of privacy, and related to this, the respect the law must pay to the autonomy of persons. Specifically excluded from any detailed comments by me will be a reflection on the medical facts and the medical assumptions at work in Schiavo. In this connection, I should note at least briefly a statement made by Dr. Stephen Nelson, reporting to the chief medical examiner for the 10th Judicial Circuit of Florida, On page 20 of Dr. Nelson's autopsy report, he notes with brevity and indeed aptness, and I quote, "Neuropathological examination alone of the decedent's brain, or any brain for that matter, cannot prove or disprove a diagnosis of persistent vegetative state or minimally conscious state." So one doesn't want to be fobbed off with the form of neuropathy and that sort of thing. The second point I'd make, and again without any discussion, is the controversy that surrounds both the diagnosis and prognosis regarding persistent vegetative states. In one recent and illustrative study, investigators, for example, found that 17 of 40 PVS patients were misdiagnosed, and fully one-third of them displayed recovery during the period of the research itself. As the investigators noted, quote, "The vegetative state needs considerable skill to diagnose. Requiring assessment over a period of time, diagnosis cannot be made even by the most experienced clinicians from a bedside assessment." So I say I can't dilate on this aspect of Schiavo, just to say that the medical certainties expressed during this hotly contested event were expressed with greater certainty than was warranted. Well, let me now briefly rehearse the conflicting testimony of Michael Schiavo and his witnesses versus the Schindler family and their witnesses. According to Michael Schiavo, he and Terry, along with his brother and his brother's wife, had watched a television program featuring a patient maintained on a ventilator. All three testified that Terry's reaction to the program was to the effect that she would not want her own life preserved in such a manner. Contradictory testimony from two of Terry's lifelong friends was to the effect that Terry had clearly affirmed her commitment to life in the matter of Karen Quinlan. It is notable that the position attributed to Terry by her friends and her parents was based on specific and principled grounds, whereas the contradictory alleged utterances were rather more vague. If, however, she ever expressed such a wish, and if her utterances were taken to be on a par with advance directives or living wills, we are in a position to turn directly to the status that should be accorded such statements. I wish to argue this afternoon that neither autonomy nor sincerity by itself or in combination will relieve the law of its proper burdens in matters of this kind. The two main components I must consider in this connection are, first, the nature of the privacy right itself, understood to ground the authority of the wishes of an actual or prospective patient, and second, the competence presupposed if such wishes are to be taken as informed in all of the relevant respects of an informed consent. Distinct from these two issues, but necessary if both privacy rights and the presumption of competence are to receive proper weight, is an evidentiary question regarding the validity and authenticity of the avowal. Put simply, what should courts require as proof of the wishes of the party at issue? I'll turn to this toward the end of my address today. But for now, what about privacy, and how does it relate to the liberty interests of the individual citizen? The issue of privacy within the ambit of constitutional protections remains contested and confused. Giving the opinion in Griswold, Justice Douglas recited the now famous assertion that, quote, "specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance," close quote. The wording here has been the source of both mirth and solemnity, owing to the metaphorical work that has to be accomplished by such penumbra-forming emanations. A penumbra, after all, is the shadow of one heavenly body projected onto the surface of another body that is partly occluded by the sun. Now, emanations from such optical effects seem to many to be less than, shall we say, transparently related to unexpressed but implicit constitutional protections. Metaphor aside, it is germane to note here that privacy from a moral point of view is really a neutral term. That is, it refers neutrally to those venues and those conditions of association under which actions take place. It is never sufficient, therefore, in morals or at law, to establish that an activity was done in private. The same indeed is so with autonomy. Autonomy refers to the presumed power or capacity of persons to do their own bidding, to frame freely a course of action, and to act accordingly. What one does with one's autonomy is that for which one is properly held accountable and responsible. Thus, no action is automatically justified by autonomy, nor is it automatically justified by being performed in a private setting. Law and morals both reach the quality of the act itself before making any judgment as to whether the venue or the degree of association or the degree of autonomy then should be weighed. The importance assigned to considerations of privacy was highlighted by Griswold, but in this the court reasoned gratuitously, and if I may say so, rather clumsily. It's obvious on its face that a constitutional order establishing a people as self-governing is of such a nature as to impose justificatory burdens on the state whenever the state presumes to constrain the liberty of citizens. The word privacy is misleading in this regard, for it seems to insulate only the actions that the state doesn't see. Actually, the immunity is far broader and extends to most of what persons will do in the light of day, not hidden by penumbras, but illuminated directly. The point, of course, is that no special set of emanations had to be found in Griswold. In any case, the pedigree of privacy is far more venerable than Griswold. If the sense of the word is drawn from constitutional considerations, one of the most influential early treatises was surely Thomas Cooley's treatise on the law of torts, in which the author underscores what he calls, and what would later become a rather famous phrase, the right to be let alone. Indeed, Cooley was thinking of the insulation citizens should enjoy from intrusive and coercive measures, but consider how he would have the right to be let alone understood. A quote, "The right to one's person may be said to be a right of complete immunity. To be let alone, the corresponding duty is not to inflict an injury, and not within such proximity as might render it successful, to attempt the infliction of an injury." Close quote. Properly understood, then, the right to be let alone is the right that bars attempts to harm. Whatever might be taken to be the motivation behind the relevant Connecticut statutes in Griswold, it surely was not to harm either Dr. Griswold or the married couple who sought her assistance. You know the Griswold thing had to do with making available advice and contraceptive devices for the purpose of preventing pregnancy, and Griswold in this case was actually a consulting, competent physician. The action then was brought by Connecticut against Griswold. Now, Cooley's right to be let alone was incorporated later into an essay of great authority published a decade later, the essay titled The Right to Privacy, by Charles Warren and Louis Brandeis. Warren and Brandeis developed the principle or theory of emanations not only from express provisions of the Constitution, but from far older common law precepts. However, for there to be emanations, there must be a source which is itself not an emanation. Warren and Brandeis make this clear at the very outset of their essay. I quote, "That the individual shall have full protection in person and in property, is a principle as old as the common law, but it has been found necessary from time to time to define anew the exact nature and extent of such protection. Political, social, and economic changes entail the recognition of new rights, and the common law, in its eternal youth, grows to meet the demands of society. Here's that organic constitution about which we've heard so much in recent years, this wonderfully elastic document. As I said to a friend yesterday, it's elastic but not liquid. But you can see that Warren and Brandeis are acknowledging that as a society grows in complexity, as the civic sense of oneself becomes ever more robust, basic common law precepts must be expanded and enlarged to meet these conditions. I continue with their essay. Thus, in very early times, the law gave a remedy only for physical interference with life and property. Then, their phrase, by the way, not the James Madison phrase, in case you think Robert George has invented all this stuff, then the right to life served only to protect the subject from battery. Liberty meant freedom from actual restraint, and the right to property secured to the individual his lands and his cattle. Gradually, the scope of these legal rights broadened, and now the right to life has come to mean the right to enjoy life, the right to be let alone, close quote. In Cooley's right to be let alone, and later in the Warren Brandeis right of privacy, the legal anchor is tethered firmly to the life right, absent which privacy considerations would be jejune. There would be later developments, of course, between the Warren Brandeis analysis of 1890 and then the landmark decision 15 years later, the 1905 Lochner versus New York. By the time of Lochner, the court was persuaded that the state of New York could not intrude itself into the working agreements between bakers and their employers. Lochner, you know, was a case contested on how many hours bakers could agree to work. New York intervened and invoked some sort of health consideration for barring these agreements of this sort. The baker who is willing to work a 60-hour week was not to be prevented from doing so by an overreaching government by way of arguably, and only arguably, compelling health laws. The worrisomely protean 14th Amendment now worked to protect the liberty interests of persons because the court found against New York and for the bakers. However, the dissenting opinion, and I don't find myself often citing Oliver Wendell Holmes in a particularly favorable light. He's an estimable person, more on that at some later date. But Holmes, in the dissenting opinion in Lochner, serves up a quintessentially Holmesian paragraph, and I think on this very much on the point. He offers a different perspective than the one that would make firmer contact with the future than was available to his colleagues on the bench. Here's Holmes in Lochner. It is settled by various decisions of this court that the state constitutions and state laws may regulate life in many ways, which we as legislators might think as injudicious, if you like, tyrannical. The liberty of the citizen to do as he likes, so long as he does not interfere with the liberty of others to do the same thing, which has been a shibboleth for some well-known writers, is interfered with by school laws, by the post office, by every state or municipal institution which takes his money for purposes thought desirable, whether he likes it or not. And here I think is a key sentence. I wish I wrote this. The 14th Amendment does not enact Mr. Herbert Spencer's social statics, close quote. The spectacle of everyone for himself out there in the jungle of the world, only the best surviving it, and doing so by dint of their vaunted individuality. The Spencerian view, Holmes thought, was not the purpose of the 14th Amendment, and the amendment shouldn't be used that way. Spencer, you know, was the one who coined the survival of the fittest slogan. Clearly, the constitutional status of privacy does remain unsettled, as must be the case. It's something of a distraction to think this status depends on the outcome of debates between so-called originalists and those who take the Constitution to be rather more elastic and adaptable. That debate can be traced to the earliest cases addressed by the Court. With the appearance of the 14th Amendment, the scope of the debate was widened, and on the matter of privacy, the Court has since that time been required to wrestle with it in varied assortments and contexts. But quite apart from the constitutional pedigree of the right are questions as to the quality of the actions covered by it. Surely the case closest to Schiavo is Cruzan, which was decided by the Court in 1990, and I think it's useful to consider Cruzan in some detail here, if you'll be patient. Well, to begin with the most direct question, it may be asked if a person's liberty interests are such as to protect self-destructive actions. Now, in his concurring opinion in Cruzan, Justice Scalia made clear that, quote, American law has always accorded the state the power to prevent, by force if necessary, suicide, including suicide by refusing to take appropriate measures necessary to preserve one's life. That the point at which life becomes worthless and the point at which the means necessary to preserve it become extraordinary or inappropriate are neither set forth in the Constitution nor known to the 9 justices of this Court any better than they are known to 9 people picked at random from the Kansas City telephone directory. Cruzan was a case that began in Missouri. And hence, that even when it is demonstrated by clear and convincing evidence that a patient no longer wishes certain measures to be taken to preserve her life, it is up to the citizens of Missouri to decide, through their elected representatives, whether that wish will be honored. And of course, what he's saying is whether that wish will be honored at law. Now, Justice Scalia might have gone further and noted that the common law precepts, fully embraced at the American founding, required the protection of life during gestation. It's sometimes said in Roe v. Wade contexts that, well, what could the founders have known about this? They obviously weren't thinking about fetuses. Their medical knowledge was not particularly developed. It wasn't what they were doing in the hot months in Philadelphia and all that stuff. Well, after the ratification of the Constitution, James Wilson, Professor Gordon Graham, a friend of mine who is now here as Luce Professor, an Aberdonian with the best of Scottish credentials, will understand that James Wilson, native Scot, got that good education at Edinburgh before coming over here and making trouble for us, as now you might. Well, James Wilson, whose contributions to the founding were exceeded, perhaps surely by Madison, but I'm not sure by anyone else in that room at that time. He was also he was Associate Justice of the first Supreme Court appointed by President Washington. He was also the one who wrote an extraordinary opinion in the first jurisdictional dispute settled by that court, Chisholm versus Georgia in 1793, in which his attack on Georgia's claimed sovereignty was so considerable that it led almost mechanically to the 11th Amendment, but that's a chapter for another time. Wilson was chosen to give a series of lectures on law. They were later published by his son. In the 12th of his lectures, titled The Natural Rights of Individuals, Wilson first distinguishes between rights that come about by way of political establishments and those that exist, he says, quote, by the immediate gift or by the unerring law of our all-wise and all-beneficent Creator, close quote. Founders could speak that way then. They could speak. Considering next the most fundamental right, that of life itself, Wilson goes on to say that, quote, with consistency beautiful and undeviating. Human life, from its commencement to its close, is protected by the common law. In the contemplation of law, life begins when the infant is first able to stir in the womb, the quickening criterion. By the law, life is protected not only from immediate destruction, but from every degree of actual violence, and in some cases, from every degree of danger. Close quote. Now, whether understood in terms of common law, or more specifically in the logic of the Constitution, the principle is the same. Namely, it is never sufficient at law to establish no more than the wishes of a private citizen to perform an action or to be its recipient, where life itself hangs in the balance. Granting the sincerity of the wishes, there arise further and determinative questions as to whether the action is lawful, competently chosen, uncoerced, consistent with relevant state interests, etc. Granting further that there may even be emanations judged in Griswold to be radiating out to form penumbras, and granting still further that privacy is one of these, it remains conjectural as to whether every and any action performed in private enjoys some protection under the 14th Amendment merely because the action is privately taken. At issue in Cruzan was the balance to be struck between the right to refuse treatment and that recognized and fundamental state interest in the protection of life, even when the source of the threat is the potential victim herself. Delivering the opinion of the court, Justice Rehnquist did acknowledge that, quote, the United States Constitution would grant a competent person a constitutionally protected right to refuse life-saving hydration and nutrition, close quote. But there are several other key passages in Rehnquist's writing for the court that bring into sharp focus the competing claims of the state, to wit, and I carry on with Rehnquist. Missouri relies on its interest in the protection and preservation of human life, and there can be no gainsaying this interest. We do not think a state is required to remain neutral in the face of an informed and voluntary decision by a physically able adult to starve to death. But a state has more particular interests at stake. The choice between life and death is a deeply personal decision of obvious and overwhelming finality. We believe Missouri may legitimately seek to safeguard the personal element of this choice through the imposition of heightened evidentiary requirements. And even where family members are present, a state is entitled to guard against potential abuses. In our view, Missouri has permissibly sought to advance these interests through the adoption of a clear and convincing standard of proof to govern such proceedings. And those who kept up with Schiavo do understand that the very contentions regarding what her actual wishes were raised questions about the evidentiary standing of what was said on either side. Well, it's easy to lose sight of the foundational nature of the state's interest and thus to fail to comprehend the sense in which the so-called compact or the contractarian theory of governance might be defended. Each person surrenders to the collected will of the governed any number of liberties understood to be available in some abstract state of nature, in return for which the protection of life and property is taken to be the predominant interest of the collective. I died in the 4th century BC. I think things probably peaked with the Constitution of Athens. I'm not defending these Lockean notions. I'm simply rehearsing them because they played very well here, by the way, late in the 18th century. It's in the nature of the implicit agreement that the individual is no longer entitled to some separate set of arrangements with the state, predicated on eccentricities of taste or passion. Now, in this light, it's instructive to consult again Justice Scalia's concurring opinion in Cruzan on another central point in Schiavo and Terry Schindler Schiavo's alleged wishes. Scalia notes that laws prohibiting suicide are indifferent to distinctions between action and inaction, once the outcome is reasonably certain. Nor is the burden of the offense mitigated by evidence of permanent incapacities. Nor is common law thwarted by the claim that, quote, preventing her from effectuating her presumed wish to die requires violation of her bodily integrity. I carry on with Scalia. None of these suffices. Suicide was not excused, even when committed, quote, and here he's going to take a passage from Blackburn versus State, an 1873 case. He says, suicide was not excused even when committed, quote, to avoid those ills which persons had not the fortitude to endure. Nay, even the lives of criminals condemned to death are under the protection of the law, equally as the lives of those who are in the full tide of life's enjoyment and anxious to continue to live. Close quote, close quote. As for the distinction between action and inaction, Scalia states that, quote, it would not make much sense to say that one may not kill oneself by walking into the sea, but may sit on the beach until submerged by the incoming tide. Starving oneself to death is no different from putting a gun to one's temple, as far as the common law definition of suicide is concerned, close quote. Scalia's position has, of course, not become ensconced in constitutional law. Perhaps it wouldn't enjoy a majority even with the recent additions to the court. But it does rehearse fundamental precepts of common law in ways that surely have informed the laws of the separate states, of our separate states. More to the point, his opinion in Cruzan exposes the weakest points of the privacy privilege when conflicts arise between the state's compelling interest in the protection of life and the rights that might be claimed by an individual citizen. Note also that where the state's interest is greatest, so too is the evidentiary burden on those who would invoke a liberty interest against it. This was made abundantly clear by Justice Rehnquist in the passages that I cited above. It's precisely because both the state interest and the liberty interest are at their greatest level of significance here that every attempt must be made to establish just what are a patient's free and informed desires. When we apply these considerations to Schiavo, the following conclusions seem to me, anyway, to be warranted. First, that such privacy rights as might be implicit in the Constitution are not without limitation. Second, that the latitude given to the expression of such rights is moderated by other rights and by legitimate state interests. Third, that the state's compelling interest in the protection of life, if nullified at all, can be nullified only by clear and convincing evidence of the uncoerced wishes of a competent and informed citizen, which is to say, by the autonomous decisions of the party at risk. Autonomy. Needless to say, this remains at the center of moral philosophy and its historic disputants. I saw a wonderful cartoon a week and a half ago of the angels. The angels are talking to God, and the angels say, and they've now all come to believe they have free will, as you said they would. So. Autonomy is a term on which rest the competing claims of determinists, voluntarists, compatibilists. If you have trouble sleeping, read my Praise and Blame. There's a very extended review, critical review of all that stuff and more footnotes than you'd ever want to see. 3 or 4 pages, you'll be out like a light. I wrote it. I have a vested interest in it. It takes about 8 or 9 pages for me. But a right of privacy is distinguishable from the faculty or power of autonomy. Nor is it the case that any and every denial of a privacy right must be at the expense of autonomy. So there's a relationship, but it's certainly not a mutual entailment in any logical sense, let alone in any causal sense. Well, if it were causally entailed, it wouldn't be autonomy. That's another subject. One is not permitted to inhale cocaine in the privacy of one's residence, but most persons autonomously would forego the pleasure in any case, and would even if the law permitted it. This, of course, was the sort of distinction Locke attempted to clarify by noting the difference between what one is at liberty to do and what one does freely. It's in Chapter 4, Section 22 of the second treatise that he contrasts, quote, the natural liberty and, quote, the liberty of man in society, where the latter is, these are Locke's words, under no other legislative power but that established by consent in the commonwealth, nor under the dominion of any will or restraint of any law, but what that legislative shall enact according to the trust put in it. Freedom, then, is to have a standing rule to live by, common to every one of that society, and made by the legislative power erected in it. A liberty to follow my own will in all things where the rule prescribes not, and not to be subject to the inconstant, uncertain, unknown, arbitrary will of another. Dr. John Locke, Dr. Nottaman, very good physician, spotted a cyst, he diagnosed correctly a cyst on the liver of Shaftesbury, his very good friend, and actually presided over an extremely delicate operation that saved Shaftesbury's life. Shaftesbury, as head of the Board of Trade for the Carolinas, actually recommended that Locke help the Carolinas draft their constitution. So he picked a good doctor, and if we're getting it right, he picked a fairly good political scientist as well. Newton's chum. Where are they now? I'm sure they're all here in Princeton. I can't wait to meet them. It'll be after today's talk. They're right outside, I know. Well, understood in Locke's terms, one is free to the extent that one has a standing rule to live by common to everyone in that society. Now, nothing in this tells for or against specific laws that might limit freedom, as long as the limitation were in a manner common to all. Law in its very etymology binds, legare, and enforces conformity to a rule. To some extent, it might be said that members of society autonomously enter into the implicit contract or covenant and exercise their autonomy by accepting the binding constraints of law. I'm not about to define law. The little etymology is just that. Aristotle tried to define it at the close of his controversial treatise on politics. It's the one all of us who teach Aristotle have to apologize for. This is where he makes the gender comparisons and the doulos physikos, the slave by nature, and so forth. But at the end, he asks what the source of law is. He says a lot of people think we get it straight away from the gods. Dio per anorexia nous onamos estin, he says. The law is reason without passion. Anorexios. He wants the law to be anorexic, you say, in the sense of orexios. Whether or not the law should respect or oppose the wishes of a citizen or the wishes of a guardian of a citizen is not to be settled by rather wave-of-the-hand references to autonomy. In matters such as Schiavo, it is the exercise of autonomy and the permissible reach of liberty interests that in fact are at issue. The questions aroused by such cases must be dealt with and not begged by simply noting again that the decision was autonomous, made autonomously. Accepting for juridical purposes that the presumption of autonomy under some circumstances is warranted, the circumstances then remain to be identified. The free action taken by one who is intoxicated is an action understood to be not free in the fullest moral sense. The free actions of a child who might put her name to a lease or the purchase of a car are understood to be not free, either in the moral or the legal sense. If then one acknowledges some zone of privacy as regards accepting treatment, where both legal and moral concerns center on the right of a person to self-determination, there will still be the question of whether this person, under these conditions, has made the determination freely, as this very freedom implies competence. Now, on this point, I must express serious reservations about advance directives, living wills, related testaments. Some of you may have these things. I state for the public, you are my witnesses, I do not have an advance directive, I do not have a living will, and anyone who might claim that I have either of these things is a rank liar. If I'm found gasping and sputtering and turning purple, I want decisions as to what to do to me reserved to the doctor, who might be looking there saying, that mass of flesh, but damn it, I'm going to save it anyhow. That's the way I want to go. Did you record that? Do you have that? Mark that down. Gordon, mark it down. That would be the case that'd be the case in Aberdeen in any case, wouldn't it? Be some young intern saying, God, he's fat, but we won't let him go. Yeah. So, even if we accept the truth and the accuracy of Michael Schiavo's testimony, the question has to be raised as to whether Terry Schiavo was competent in stating the wishes that he attributed to her. If experts in clinical neurology are scarcely unanimous or precise in establishing just what is entailed by the term persistent vegetative state, it's not to be expected that an ordinary citizen would have anything but a very vague sense of its meaning and its significance. To say, if I'm ever in such and such a state, ... really may ask too much of one's auditors and may claim too much knowledge for oneself. In brief, it is always in order to be wary of advance directives, living wills, and non-contextual affirmations. There's a literature on this, by the way, and it's an interesting literature, a literature based on what people say in their advance directives and living wills. If I'm ever, then I don't want any of this. And you know what happens when they're actually laying there and turning purple? And the doctor says, well, I do have this mammiocum stuff. Give it to me, you say. If I'm ever in such a state, easily said. How many times have you said, well, if I were there, you know what I would have said to him? And then you're there and you... Might the courts and the citizenry be more deeply informed by the growing community of experts in medical ethics, bioethics? Be careful of what you hyphenate. If there is a good argument to the effect that one must not take Jack's liver, then it's going to be akin to the argument according to which you shouldn't take his car or his house. And it's not entirely clear that some new set of ethical precepts is engaged every time the scientific community develops a new low-noise amplifier, if you get my point, you see. Bioethics. An amicus brief was filed by 55 of the leading bioethicists in the United States, major figures. I didn't know any of these names, but I'm sure that they were major figures. Well, with respect to this part of the story, doubt sinks rapidly toward the level of derision. It was at once alarming and perplexing to observe the consistency with which members of the bioethics community were of nearly one mind in their support of the courts and of Michael Schiavo's rightful authority as a guardian. That there would be such uniform approval of measures designed to cause death by starvation and dehydration was the fulfillment of prophecies emanating from bioethics centers years earlier. Daniel Callahan, director of the prestigious Hastings Center, observed as early as 1983, I believe I gave lectures there in 1983, so much for the staying power of one's rhetorical achievements, do you see? So while I'm lecturing there, Callahan must have been up in his room writing this one. Quote, Denial of nutrition may, in the long run, become the only effective way to make certain that a large number of biologically tenacious patients actually die. Remind me, I'm not going to have Dan Callahan to certain functions. He goes on. Given the increasingly large pool of superannuated, chronically ill, physically marginal elderly, I'm going to be 69 years old tomorrow. I don't like this kind of talk. It could well become the non-treatment of choice. Oh, Dan. Note the main objective, cited here without any evidence of regret, let alone horror. The main objective is to unburden the system of tenacious patients by starving them to death. I mean, this is sort of a double win, isn't it? You save on the food bill and you get rid of the... Well, next came the group of, quote, 55 of the nation's leading bioethicists, close quote, who did file an amicus brief in support of Michael Schiavo's action in Florida's Supreme Court, where Schiavo attempted to block Governor Bush's intervention. The amicus brief begins with a statement of what they call the 4 central values that arise from the moral traditions of medicine and nursing and from the ethical, religious, and legal traditions of our society. Well, that's quite a bit of authority to pack in there with just... Now, what's the source of all this? Why, the Hastings Center guidelines on the termination of life-sustaining treatment and the care of the dying. H.L. Mencken once defined a judge as a law student who grades his own examination papers. Well, what are the 4 central values? 1, beneficence. I think I'm going to cry. 2, the integrity of healthcare professionals. 3, justice. 4, personal autonomy. Well, of course, from a moral point of view, none of these can stand as a central value until their modes of expression and resulting effects are specified. Consider the amplification of the value of autonomy. They say this about it, quote, "We respect human dignity by granting individuals the freedom to make choices in accordance with their own values," close quote. Of course, it's patently false that respect for human dignity requires the undeliberated and unevaluated permission to act in accordance with one's own values. We'd have to know what the values are. Jeffrey Dahmer's dietary preferences might actually have been grounded in a certain deeply held, sincere religious conviction. Not good enough. No, sorry about that. That you're sincere about this only makes matters worse. The law itself, not to mention moral philosophy, takes cognizance of just those values in seeking to judge their worth and such respect as they might deserve. So too with the integrity of healthcare professionals who, according to the amicus brief, quote, "have a right to remain true to their own conscientious moral and religious beliefs," close quote. Now, moral and religious beliefs can be conscientious, but entirely unacceptable within a setting established to foster health and well-being. The Santeria expressed their religious conscientiousness by bloody sacrificial rites performed on animals. Now, surely members of the sect who just happened to be nurses or doctors could not plausibly claim the right to include Afro-Caribbean magic as part of a therapeutic regimen covered by Blue Cross, or at least not yet. The alleged right to remain true to one's moral or religious beliefs is, as with all other rights, bounded by considerations of time and place, statutory constraints, public safety, public decency. The list is really very long. Failure to address these boundaries directly reduces the bioethicist's core values to pieties, just platitudes. Well, they're not platitudes. Well, as might be expected, the amicus brief rises to its greatest rhetorical height on the wings of personal autonomy. For, quote, no legal right is more important in American society. Now, how on earth could they know that? Do you see? This is a category mistake. There are just a lot of people living here. There isn't an American society over and against Jack and Jill. No legal right is more important in American society than the right of personal autonomy, each person's fundamental right to the sole control of his or her person, close quote. The fragment quoted within this passage that I've just given you is not from the Constitution of the United States or the Bill of Rights. It's not from the Federalist. It's from a Florida guardianship case. That's where that quote comes from. It's in re guardianship of Browning, 568, Florida, 1990. It should have been in some insurance case in New Jersey, maybe, with a bicycle run over by a truck. I mean, when we start talking about the core values of American society, it should be a trite case, not a serious one. As with so much of the impressionistic reasoning now featured in judicial proceedings, this passage, too, might have been better placed in an ethics primer, where it would give dangerous solace to the uncritical reader. One's next-door neighbor, if not a specialist in bioethics, and if queried on the subject, would surely be less than certain that there is no legal right more important than autonomy. One's neighbor would presumably place the highest premium on being secure in his life and property and in the lives of those closest to him. The basic rights set forth by Madison in the first 10 amendments to the U.S. Constitution do not mention and arguably do not even envisage autonomy as a right. It is instead a power, it's a capacity, the use of which renders one fit for the judgments of law. In all, then, the 55 of our nation's leading authorities in bioethics shed no light and much fog over the issues in Schiavo. I am not being unfair to them here. Read the brief. It's very poorly done. It would be poorly done as a minor's thesis in philosophy by a student who had 6 credits in moral philosophy. Well, no, 6 credits in ethics, 3 of them in bioethics. Would write something like that. It was a terrible performance. Incredibly self-conscious, pompous, and stupid work. It's the sort of thing where if you have to sign it, you make up a name for yourself. In the heated environment of Senate confirmation hearings, candidates for appointment to the federal courts are often asked the question, do you believe privacy to be a constitutionally protected right? How often did we hear that during these Supreme Court? Do you believe, it's a very rude way to put a question. The way you put the question is, I wonder if you might comment on the notion of a privacy right. Do you believe privacy to be a constitutionally protected right? It's permissible to judge a question of this sort as little more than an appeal to a constituency, for as stated, the question is too simplistic for a serious person to answer. It has no content, either with respect to the putative right or to the range of actions that would be protected by it, just in case it's a right. Content could be supplied in this form. Do you believe that starving a child to death in private is constitutionally protected? Again, just what actions and under what conditions are at once private and then constitutionally protected owing to a respect for privacy point to the central part of a long debate on where one's individual liberties, confronting lawful limits, which is going to bend, which one hopes will not break. That's the tension. We live with this 7 days a week. It's an ineliminable aspect of civic life. It's like mowing your lawn, at a lower end of things. It's the things you have to yield to so that others also might have some robust, decent, and joyful moments in their own lives. Even rock and roll music, do you see? It's all right. Can't spend all your time with Schubert. Terry Schiavo entered a twilight time in life, and she remained there for many years. The parents who so loved her and continued to see the little girl they knew, the young woman, the eager bride, the worried wife, well, less clear is perhaps what Michael Schiavo came to see, both before the tragic event and then in the years that followed. Cases such as this are the stuff of drama. And as with all tragic forms of drama, they are lessons, they provide warnings, they send up signals, they alert us to things we might have been complacent about. Cases like this will lead some toward pastoral guidance, others to lawyers and the composition of wills, others to the security that might be felt among like-minded friends and neighbors. Well, as all this proceeds and gives yet another and deeper dimension to life, there does remain the fact, and here I refer to the legal, the moral, and the civic fact, of what the Florida Constitution itself calls a natural person, now holding on to a life that can claim little more than a past and an empty future. Here is a natural person whose condition allows us to see just where we set the bar on the value of life. As the bar is raised above the place where Terry Schiavo was sustained, society must address its collective moral conscience and ask candidly whether this is a victory for the right of privacy or a concession to what Daniel Callahan calmly predicted more than 20 years ago when, as I've noted, he observed that denial of nutrition may in the long run become the only effective way to make certain that a large number of biologically tenacious patients actually die. Thank you very much.
Thank you, Professor Robinson. We have time for questions. May I ask, first of all, for student questions?
Yes, I have that effect very often. Student questions.
There we go.
Now you were taunted into doing it.
It seems to me that one of the most compelling facets of the argument is that it is the states in their moral deliberations of the legislature to decide how and under what circumstances decisions as to the rights or decisions as to the end-of-life treatment or non-end-of-life treatment of persons such as Mr. Schiavo are to be left to the state legislature. In as much as those states have made a decision that life should be protected, all seems fine. What if the states were to make decisions somewhat in line with what Professor Singer said here and end up actually terminating a lot of lives that are judged to be in the least interest of society from a cost standpoint, from an attention standpoint, from whatever standpoint they wish to defend their utilitarian philosophy on? Does your framework provide an argument against them, or do you have to say hands off that?
Well, no, it's a profoundly important question. I should say that one of my Oxford colleagues, John Broome, who holds the White's Chair in Moral Philosophy, which is the oldest philosophy chair in Europe. John's an economist, and John's work over a course of many years has been devoted to the question, what is the value of life? And he means this as a trained, serious economist would raise questions about value. It means, given the resources you have available, what fraction of the overall resources are you ready to deploy for the sake of preserving that life? For how long, under what circumstances, and so forth. You know, because you've addressed the subject as a student, as a young scholar, that I'm not going to answer that question here. I am going to say, however, that much of the Bill of Rights is actually at the expense of what I would call a consistent consequentialist moral theory. A consistent utilitarian theory, given what it sets out to maximize, certainly would not accord to the individual the range of protections, the liberty interests, over and against those of very sizable majorities that would play out on you mentioned Peter Singer, I would guess on Peter Singer's scheme. My own position on this should be of very, very little interest, but I'm quite good at telling you what a lot of other people have thought over a long period of time. The ancient world was not solicitous of the values of the individual insofar as they were individuated. There was a remarkable development in ancient Greek law, we're told initiated by Solon himself, because prior to Solon's reforms, the prevailing scheme of justice was fratric justice, which is to say, if a member of my phratry or tribe suffered a loss, an injury, as a result of something done by a member of yours, it was not necessary to find out who in your tribe did it. It would be sufficient to retaliate against anyone in that tribe, just in case you didn't produce the offender. Solon's reforms pin responsibility on the actor. One might say that this is a very early recognition in law of individual responsibility. But, well, no, if we go with some sort of utilitarian scheme, legislators surely are going to recognize that what it takes. Here's the bottom line. From a physiological point of view, I don't know any living system that in principle can't be kept going, or some piece of it going. Lots of pieces of it going. And it depends on how much you're willing to invest in this. Now, sometimes the decisions at law have and are intended to have a rhetorical value to them. That is, even where practically the law cannot achieve its aim. In stating its aim, it encourages a form of conduct judged to be desirable. Hence Hegel's phrase, what the law permits, it encourages. And I would say then that legislators who say, you're going to be in deep yogurt if you're willy-nilly about ending a life. Look at me now, I'm using an audiovisual aid. And then have competent medical people who did not get all that schooling in order to develop sophisticated ways of killing, then allow, in a chapter that I've done on Schiavo, which Cambridge is publishing next year, I do have some recommendations. One recommendation is that in cases of this kind, where there are disputants of comparable standing, the disputant who favors the preservation of life gets the nod. That is, where the evidentiary requirement can't be fully met by either side, the nod goes to the side that says, keep the machinery going. When in doubt, primum non nocere. Or after Holy Mother Church, no cede. The only way I can read an Italian newspaper is assume it's bad Latin.
Questions?
The parties in Schiavo were certainly not Oxfordian faculty.
Thank God.
Princeton faculty, having just written a treatise on what should happen to life. But as one of the 19 or whatever, she sees somebody in a dreadful condition, want to be like that. And that seems to have been the pivotal piece of evidence on the case. Maybe I'm wrong factually about that. That was the sense I got with the proceedings. said, oh, well, you know, I mean, when you have people like this, there's not much there anymore. So, you know,
Hawking is something like that, isn't he?
quite a bit. And so, you know, it seems like many people just react really in something entirely different. Their bottom line really had nothing to do with legal reason. Then it takes me finally to the statement that you just made about when there are two parties of equal standing, you favor the one that favors life. I think that's the sense a lot of people have in this, and yet there was no mechanism in the law whatsoever to effectuate.
By the way, I really don't want to be any more tedious than I have been, because there are some intricate details about this case. Let me just say this much. The friends of the deceased, who claim that during the Quinlan period she opposed the decision of the family to terminate the life support systems. Judge Greer, who was the probate judge who settled this, and this is how it's done in Florida, he discounted their testimony because they referred to something that Terry Schiavo said. I wish I had my full chapter here. Something she said in 1985, and he said this couldn't have been the case because Quinlan was settled in 1973. Now, the briefs and oral arguments before the Supreme Court of New Jersey in the matter of Karen Quinlan are published in 2 volumes. They came out after the Supreme Court decided it in New Jersey. And I wrote the introduction to those volumes. It's quite up on every aspect of Quinlan. I'm the one who said if they take the tube out and she resumes breathing, she could last for 10 years. And, of course, everybody would go, ha-ha. Don't go ha-ha. And she did last for 10 years because when they moved her to a new facility, they had to take the trach tube out, and she started breathing again. Well, Terry made this comment after a movie on Quinlan was seen on television. So there wasn't any disparity in the dates. And when hit with that, he did not think that was sufficient to reconsider there were tremendous problems with this. And I want to stay away from those because at the level of principle, you don't want it settled by some probate judge being in a persistent, incompetent state. As far as what people say they don't want done to them, and I think it's very important for you to know this, just in case you've written an advance directive, the likelihood that when you're wheeled into an emergency room, anybody in that room will have access to your advance directive or will stop what they're doing to read the thing is very low indeed. And just in case they do read it, just in case they know well in advance of your getting there what your wishes are, research shows that they follow those wishes about a third of the time. Here's the bad news if you're somebody who doesn't want to be like this. Doctors have this persistent habit of saving a life. Becky Noterman can explain where this zeal comes from, but chances are, one of New Jersey's distinguished pediatricians, I mean, if somebody wrote down something about how they wanted to be treated, and they came in terminal stages of a condition that otherwise is treatable, I can't imagine seeing Becky Noterman standing there reading this damn thing, and no. So let the doctors decide. Well, I think in some of these very difficult cases, look, if you're prepared to entrust your life, your well-being, the lives and well-being of your spouses, your children, and so forth, to people you've never met on the basis of what you take to be their commitment to your best interest, then it seems to me that in those final hours, that probably should be the community of choice.
You're in with a statement that you hear a lot in the courts. That hard cases make
Bad law.
And I don't know whether Schiavo is good law or bad law, but it's debatable. It's a hard case.
It's a hard case. Yeah. Yeah. I would be inclined in this general area to see to it that very hard cases don't quickly make law. See, it's possible for difficult issues to be settled beyond the range of adjudication, litigation, and so forth. Now, what made this unavoidable, of course, is you did have two contesting parties, so courts are there, among other reasons, to settle disputes, and there wasn't a dispute. But I say there were all sorts of things in Schiavo that are extremely worrisome, having to do with how her assets were being managed by him, these insurance gains, and the fact that he was fathering children in another relationship while legally married to her, who would be the beneficiary of the insurance. But that's a case where you can just paint characters black and white and have your way with them. So I'd rather just stay at the level of principle. Now, on Dickens, look, there is a progressive refinement of the rule of law, just in case those prepared to live under it progressively refine themselves. Law is not some entity separated from life as lived. It is indeed, I don't want to sound like an unreconstructed legal positivist here. I certainly don't want to sound like Kelson. But of course it is something we make. Not as we make clay pots, but it is something we devise. And what we devise is a reflection of our powers. And our powers are a reflection of how we live our lives and how we think through things and how we shoulder responsibilities. Where the law is an ass, it's presiding over asses who made it that way, you see. And very often it's necessary to accept the fact, we all do this all the time, that the law is going to bind us in ways that we don't like, often under conditions not of our choosing, and to some extent to the advantage of others that we believe don't deserve that advantage. And then we have to step back from particularizing that and ask whether the maxim being affirmed by that legal remedy or that law acting over the long course is going to achieve ends consistent with the moral purposes of a decent people. So, I did do that, write that book on wild beasts and idle humors, in which I wanted to argue that the achievements of medical jurisprudence are not what we think they are, and that these insanity cases would best be settled within the framework of judges, juries, contesting lawyers, and not spend a lot of time on the Diagnostic and Statistics Manual of the American Psychiatric Association. And the book got very good reviews, but one of the review in the Federal Lawyer was, and the author's prepared to leave all this up to lawyers. Imagine that. So leaving things up to doctors. Imagine that. Well, at the end of the day, you've got to leave these things up to somebody. And I would say that where life is at issue, you leave the decision up to one who's affirming life, unless there's overwhelming evidence to the contrary, unarguable, almost unarguable evidence to the contrary.
In the back there.
At the same time as Schiavo, there was a Texas case where a mother wanted her son to be kept alive and the state didn't want to pay for that. Your rule of thumb here, it's decide in favor of losing life goes against actually a lot of states that don't want to pay for affirming life. How would you deal with that kind of situation?
Well, as I, what's your name?
Michael.
Yeah, when Michael raised the question about how much you're willing to invest in this, I did own up to the fact that I died in the 4th century BC. But if I were revived today and looked at the scheme that we live under, well, it is in the states and their legislatures that decisions are made as to how the resources of the community are to be committed. No individual has trumping power over those decisions, and you don't gain it merely because you're dying. So perhaps a more informed electorate would look for people who might be rather more generous in this regard. But that these things are settled according to the best judgment of the people through their legislative bodies. It's just the way we do things. This is a room that has in one side of it friends of mine, Robert George and George Kateb, whose positions, I should think, on the extent to which the law has to embody, reflect, and be obeisant to core moral precepts would be very divergent, you see. And that's something that we reserve to the seminar room and must. And if the law is improved over the course of time, it's because distinguished scholars worry themselves pink to get this right. But at the end of the day, we decide these things. And on the question, how do we value life? Schiavo is the sort of case that puts one's feet to the fire. The Texas case is another one. I don't know what the costs were. I don't know that a medical facility can decline to treat a patient on the basis of inability to pay where life is involved. I suspect that the hospital did not have that option. I don't know. I'd have to know the details of that case. Do you know the details of the case?
If I remember correctly, the state law mandated that they not. The state wasn't going to pay for it. Somebody else could pay for it, but the state was no longer going to.
Was this a patient in a hospital?
Yes.
And they were going to terminate treatment with the certain knowledge that it would lead to death because of non-payment?
Yes.
This is the sort of thing that could get me to go to law school. I mean, I'd take that one on. I think I would take that one on. You can't bring an action against the state, obviously, but you could start moving toward the person whose hand was close to the outlet. Yes. Oh, and yes, I think you went first.
As you well know, the Supreme Court just recently decided the case in Oregon about position on suicide. I realize we're talking about two slightly different things here with the Schiavo case and suicide, but whether or not the law is an ass, one of the precepts of the law, it's always seemed to me, is that in addition to governing commerce and what occurs in a courtroom and even a divorce case and so on, it also establishes the penalties for those who violate the law. A violator of the law is subject to some kind of punishment. And my question for you has to do with the appropriateness of a law prohibiting suicide when the punishment for it cannot be administered.
Well, most suicide attempts fail. So there you do have an opportunity to impose a penalty if you think you want to. If the question is how much punishment can be inflicted on a dead person, probably not much. Perhaps a zealous state could have some kind of hall of dishonor threatening to put your name on it just in case you deprive us of your tax revenues annually. But as I say, the law has rhetorical purposes, and it also has a certain consistency requirement. If the law takes a position that it will defend innocent life, then it's in a position to take that position where the threatened innocent life is threatened by the hand of the prospective corpse. It just can step in. It can step in to prevent it. To say that it's not lawful is to say, among other things, that if it can be prevented, then lawfully it will be prevented. And I say it's look, I don't want to be the answer to the question what's wrong with sentimentality is that it cheapens sentiment the way all inflationary processes do. I don't want to be a sentimentalist on this issue, but there is a sentiment which I would regard as a noble sentiment to favor the least among us. You don't have to whip out the Bible. There's passages in the Bible would not match up in any meaningful way with our dispositions if there were not those dispositions. It would just be another book, you see. We do have this strong inclination. I might sink to the level of some evolutionary poppycock here, but there seems to be a strong inclination, absent which I'm not sure we would have got here, to care for the weakest among us, typically infants, for example. And this may generalize into a kind of Good Samaritanism. Where the law requires this, to some extent, it is an echo of that very deep sentiment and enduring one. You know, when Aristotle asks, what is it about the law that finds us attached to it, he says it has a particular property, which in the Greek is philikon. It has a friendly property. What he's saying is that the law, like the good friend, would have us do what's in our best interest for our sake. So the law binds, but I mean, it's not a whip and a chair. It's very often summoning us to do what we have an inclination to do anyway, and what, with the support of law, will translate that inclination into action. So I do think it's a very good idea for the law to threaten to punish failed suicides. Yes, I know it's we can all have some fun with that one, but certainly to threaten punishment to those contemplating that act, where the law is able to intervene before it's undertaken. You want the state, you know, we're self-governing, we're the state. And what we want to say to each other is, under all circumstances, you matter. You see. Quite apart from the honorarium. May I say it would have to be. Yes.
Because you did raise that issue, because I think when you politicize the ethic of decision-making, absent in your discussion on religion is the element of the political environment in which those decisions on how to proceed along the ethical
Right.
is imposed. And the other side of that question is the comment about how the law, and getting back to when the law first became something that was codified in the next sense of words. In the present environment,
Yes.
If you talk about the ethics of caring for the weakest among us and the most economically deprived and intellectually deprived among us, who are going through the justice system absent the financial resources to retain a lawyer of competence so that a competency matter so that they can get a clever and robust defense. It is an ethical question that I don't think well, you may be thinking of that, but I don't think it is as simple as saying that, well, yes, we should reward the undeveloped and decide what they have to do.
Right. Well, I certainly would well, let me take them in the order in which you raised those two very important points. The burden in Schiavo was not the degree of neuropathy. It was the express wishes of Terry Schiavo. That's what settled the case. Therefore, there was widespread agreement as to profound changes at least in the gross anatomy of the brain. This aging figure before you earned a PhD in neuropsychology, and I published fairly widely in the brain sciences for about 20 years. So this is not an area. This is not an area in which I'm an amateur, as it happens. When I looked at, they did put on the internet the MRI results, and my wife asked me. I didn't read the caption underneath. I just looked at the thing, and she said, "What would you say?" I said, "If I saw these in my earlier incarnation, I'd probably say it's a late Alzheimer's patient." And then I read the caption, and the caption from the radiologist who did it said, "Not unlike terminal stages of Alzheimer's." But the reason I put in the snippet about the autopsy report is you can't look at data like that and make statements about what might be going on inside the barn. But I'm prepared to say that there really wasn't anything going on inside the barn. That's what makes this an important case. If we agreed that in this state of enduring quasi-somnolence, there were all sorts of enactments and etc., then the case, the issue would settle itself. You don't kill people because they're sleeping. So now, on the, I hope I've addressed that part of the question. The burden in Schiavo was not the degree of neurological impairment. The burden was to establish what the wishes of the patient were in regard to preserving whatever life she had. Now, if the question then is, how would I address the matter just in case the burden had been on the degree of neurological deficit? Well, this, of course, is always going to be contentious. Let me give you an illustration from Quinlan. Quinlan had never displayed an aberrant EEG. There was some slowing of some alpha wave slowing, but she satisfied none of the prevailing Harvard criteria of brain death. And so you certainly would not have a basis there. Yet, from a functional point of view, her nervous system was not able to mediate conduct or apparent experience to any extent greater than what one saw in Schiavo. So I might turn the tables and ask you, well, what would you do in a case where there is not profound neuroanatomical changes, cerebral atrophy, etc., but you have a persistent vegetative state? And I don't think it's useful to try to settle this on the grounds of medical evidence, though I think the medical evidence is one of those factors to be considered. In Schiavo and in Quinlan, the core question is, how much by way of a participating life is the ante to get in the game where our fellow citizens express their regard for us through law? Quinlan's important. Schiavo's important, I say, because these are the cases that tell us where we're setting the bar. On your second point about perhaps my sentiment bordering on sentimentality might have made mention of the fact that large numbers of our fellow citizens can't get representation in court that would give them anything like comparable access to the bounty of the rule of law, I concur completely. I had coffee with a dear friend, with George Kateb yesterday, and we were talking about Tom Paine. And Tom Paine, as you know, had been declared persona non grata when he arrived in England. He was going to say that same nasty stuff that he was saying over here. Here's your Trivial Pursuits question. He was told at a dinner party to get out of town by one of his great admirers, because if he was caught, he'd be tried and probably executed. Who told him? The poet Blake told him. So he goes off to France, and his friends put him in jail, and he writes The Age of Reason and all that. Nonetheless, he's tried. And we know what the Crown wanted to do to Tom Paine. So who did the Crown appoint as his defense counsel? The greatest trial lawyer in the realm, Lord Erskine. Edinburgh educated, of course, all the great lawyers, all those great... You see, where they're very, very good and they're English, they're referred to as great English lawyers. Where they're Scotsmen, they're referred to as great British lawyers. You see. All of the great lawyers, most of the great lawyers were British by way of Edinburgh, as Gordon Graham well knows. Erskine's defense of Paine is one of the most profound defenses of liberty of conscience and press freedom that you'll read. At the risk of annoying Professor Kateb, I do think it's better than John Mill's, and I'm a great admirer of, I've written on Mill, great admirer of John Stewart. It's a lawyer's defense. And I think that's the sense in which it has more traction. So yes, I mean, if I rig the system, the lower your income, the pricier your lawyer.
I think
there's a question right in the back.
A brief question.
Would you mind commenting, as you've been talking, I've been thinking a little bit about Socrates and the Apology and other martyrs. And these seem to be people that think a certain kind of life is such that in the absence of having that kind of life, it would be better not to have sheer biological existence any longer. And I wonder if you could comment a little bit on that with respect to this value of autonomy and the notion of looking into the future and saying, you know, a certain kind of life would not be a life worth living. And say a little bit about what is different about that in the context of a case similar to Schiavo's in relation to the case of the martyr.
Well, Socrates' society, his Hellenic culture, was a culture of heroes. And almost all of the writings, never mind him running around the marketplace as a gadfly and so forth, the participants in these dialogues, in these disputes, were all drawn from the ranks of what the ancient Greeks referred to as the kaloi kagathoi, rather oddly translated as gentlemen. The proper translation would come closer to knights errant. These were persons not just hardened in battle, but aspiring to a kind of Homeric standing. And what they might say quite grandly about the quality of life that would have to be attained to make life worth living is the sort of thing that might come out of emblem books in the 17th century. Bunyan might say something, you know, and Virgil, of course, picked up a lot of this stuff. Most of us, I think, are not drawn from the ranks of Homeric figures, and most of us do not regard our lives as having as a necessary warrant Homeric dimensions. We like to think that a cup of tea and a piece of cake in the afternoon and some quiet conversation with people one loves is probably good enough, and if we can't do that, well, then at least the tea and cake. And if we can't do that, then at least the cake. Now, how far down the line? I'll wrap this up quickly, but let me tell you about one case I do know about, Clive Waring, who was one of the great interpreters of the music of Lassus. If you know Lassus as a Renaissance composer of consequence. Clive Waring had a group that performed these pieces. There are wonderful CDs of theirs. He developed a bitemporal encephalitis that so stripped him of memory that he cannot knit together experiences that go back more than 30 or 40 seconds. So for him, the day begins every 30 or 40 seconds, and if you go out of the room and wait for about a minute and come back in, you get a greeting as if it were the first time he ever saw you. His bed in hospital is covered with notes. He was trying to knit together an hour for himself by composing notes. And when his wife would come in and talk to him and how gentle she was with him and would say, but these are your notes, don't you recognize it's your handwriting? And he'd get angry. He'd say, you stupid woman, of course it's my handwriting, I'm telling you I didn't write it. You'd get extremely agitated. Imagine yourself in this state where you're looking for yourself twice a minute, and this will be the case all the days of your life. We had Clive Waring's group assembled for the first program we did in the Mind series. It was a joint BBC-PBS production. He knew that he knew music. He didn't know quite that. Brought him to a church, sat him down at the keyboard. Groove was there, and the minute the fingers hit the keys, everything proceeded magically. I even suggested to his Scottish neurologist that instead of having him write notes to himself, he should try to score his experiences. He should, you see, you want to tap into templates that are still functioning in the system, and if they're functioning enough to read out this way, they may be functioning in yet other ways. The burden. If you told Clive Waring 6 months before, this is what the rest of your life would be, he would say, kill me now. But when that question is actually raised with him, post-traumatically, how much care he wants all the care he can get. We do hold on by it. I think it's a good idea that we do. I know we can be awfully boring. What did Dan Callahan say? What sort of patient? Just holding on too long, that sort of thing. Callahan would be very, very disturbed to realize how long they'd have to starve me to do me in, he said.